The following program is made possible in part by the Dayton Bar Association.
Your phone turned off. That's a good question. I think so. I'll get y'all some real estate on the air here.
Good evening and welcome to You and the Law. I'm Mike Monta, your producer and host for today's program. And we are talking about the topic of real estate tonight. So if you're going to be a buyer or a seller or just thinking about owning some property, keep tuned in and call one of our guests. And we have two experts tonight. One, Gary Froelich, is a local attorney specializing in real estate and is the president of the Ohio Real Estate Commission. And Mr. Mark Kottman, a realtor with HER Realtors. He's the founding partner of that organization and is the president of the Dayton Area Board of Realtors. Before we get to our discussion tonight, let me remind you that You and the Law is a monthly presentation produced here at the studios of the Dayton Access Television. DATV is on Channel 5 of the public access channels of the Time Warner Cable Network, at least for now, and it might be something different next month. But the program is also cablecast on tape delay, and you can see it through the auspices of the Miami Valley Cable Council, north or south. The program also streams live at DATV.org. Executive producer for today's program is former domestic relations judge and the originator of this show back in 1988, former Judge Mike Brigner. This is an audience participation program. You will see a number on the screen periodically, which is 223-5311, and you can call in with your questions about tonight's topic, which is real estate, and will be answered by either Gary Froelich or Mark Kottman, our experts. So let me say one more thing, and you saw at the beginning, we're sponsored by the Dayton Bar Association. We'll tell you a little bit about that as the program goes on. So let's turn to our guests now on tonight's program and let them introduce themselves to you, tell you a little bit about their backgrounds and familiarity with tonight's topic. And we'll first turn to Mr. Mark Kottman. Mark, good to have you on the show.
Thank you, Mike. It's a pleasure being here, and thank you for the invite. As you said, I am a licensed agent. I've been licensed for 38 years, currently with HER Realtors, and I am president of the Dayton Area Board of Realtors. That position is a one-year stint, runs from January to January. So my replacement next year has already been put in place. It'll be Ralph Mantico with Kensler Realty. A little bit of background on myself. I've got a degree at Wright State University. I've got a major in accounting and a minor in finance. Got into the real estate industry directly after getting out of college. Married, live in the Bellbrook area, have three children. Last one's in college right now.
Great, thanks. Good to have you with us.
Thank you.
And turning now to Gary Froelich. Gary and I have known each other for years and years and years. And he is a person who has great expertise in this, and he's going to tell you about it right now.
Thank you, Mike. It's a pleasure to be on the show with a young person like yourself. And as you know,
You're welcome.
I've been practicing law since 1968. And a substantial amount of my practice involves real estate transactions. Beginning in 1970, I started teaching the course of real estate law as an adjunct professor at Sinclair College, and I'm still teaching that course today. Back in 1977, I was retained by the Ohio Real Estate Commission to write a manual for the state of Ohio on the subject of real estate law. And then in 2008, I was appointed by the governor to the Ohio Real Estate Commission as the public member. And I'm still serving on that. It's not a full-time position, that's a volunteer type of position where we meet once a month.
Okay, great. Good to have you here also. Great to have both of you here. let's talk some real estate. Probably our viewers out there are thinking, I want to buy a house, I want to sell a house. Why don't we start with some of the steps we go through and who should be involved and why they should be involved in that? Mark?
Well, from a seller's perspective, I think it's best to get somebody involved very early in the process, maybe even months before you're interested in going on the market, just so that you can get a different set of eyes from someone that does this on a full-time basis and does it for a living. Give you an idea of what you need to do to get your home in the best condition that you can possibly get it in, so that you can market it and get a buyer fairly quickly. It's important that the home be showable. Secondly, it's important to use an agent. I think that the importance of using an agent is threefold, actually. It gives a lot of it has to do with the marketing of the property. I mean, making sure that the property is marketed properly, making sure that it's put in the right hands, making sure that all the networks of advertising are used, both paper as well as social media, Zillows, Googles, all the websites that are out there.
Well, let's say that maybe this isn't beyond the realm of possibility, but let's say I'm 25 to 30 years old. I might be married, I might not, and I'm renting. I have a job, but I would like to own my own home, and I'm not even sure where I want to live necessarily, but I've got an idea. What steps would be good to take to start the process, do you think?
One of the terms you used is home. And when you think about that term in our culture, home is your place that you think is very, very important. For everybody, being in their own home, they want to know that they own that home and they want to understand their rights. And also, for most people, buying a home is probably the most significant financial transaction that they're going to make. Buying or selling a home involves more of their finances than probably anything else in their pocketbook. So they should treat it with the respect and the complexity that it deserves. So they should think about that. And I think Mark's comment about not putting a sign out and not rushing to go in to buy a home, before you should think about talking with counselors, either professional real estate agents or a lawyer, before you enter into the transaction.
Okay, so you should have some idea of what you want to buy. And I did use the word home, but I guess this program could be about buying a shopping center or the corner store or something like that. But I think you'd probably agree that most people, that's what they're doing, isn't it? They're buying a home or they're selling their home and maybe moving somewhere. Does a seller have to go through some of these steps, or you see a lot of for sale by owners signs out occasionally? Is that a good idea, or do they have expertise enough to do that? Is this a simple enough process where you just put it out and have somebody come and buy your house and you move out, or is there more?
It's a much more complicated process.
Okay.
Yeah, you need to find someone there's a lot more involved in selling a home simply sticking a sign out in the front yard. And one of the things that they don't take into consideration, many people have a very tight, have a very close feeling about their home. It's been their home for 10 or 15 years. And they have a difficult time when somebody comes into that property as a prospective buyer, and in actuality, the floor plan doesn't work for them. Maybe there's something about the house itself that doesn't work. Maybe the decorating is atrocious, and they tell them that. I mean, it's difficult to handle objections when you actually own the property yourself. From a third-party perspective, an agent can step in, get those objections, and handle those objections privately away from the owner.
What, as you said, the owner is probably too close. their familiarity with their own home. They know all the nuances, all the good parts and the bad parts, and they're probably, when they're selling it, remembering more of the good, and the buyer's probably looking for more of the flaws. So I've always heard, and maybe this is just an old wives' tale, that you put a pot of coffee on and bake some brownies. Does that help, or is there going to be more required than that?
Gary?
There's a lot more required than just baking brownies or putting the coffee on. We have a lot of laws concerning this very important aspect. Everything from what should be disclosed at the time of sale by a seller.
Why is that important that the people disclose things?
The law of the state of Ohio for purposes of existing residential properties is called caveat emptor. When you buy a home, you buy it in its existing condition. So if something goes wrong the day after you buy it or a year after you buy it, the buyer is responsible for that. Now, if that problem was the result of something that the seller knew about and didn't disclose, then the buyer may have certain rights or certain remedies. In Ohio, we have adopted what's called the Ohio Residential Disclosure Form, which in transactions should be filled out in a residential sale, where the seller is asked certain questions about the condition of the home. So if they know things, they have to disclose them, if there are material, physical factors involving the home.
Okay, when you say that, you're talking about things that would influence the value of the property. You can, tell me if I'm wrong, but you can sell a property with flaws as long as you disclose it and the other person is cognizant of what they are and agrees that they'll evaluate the price accordingly.
As long as they're willing to accept the flaws, then everything's been put out on the table. Everything's in agreement. You mentioned for sale by owners. The form that Gary is referring to as a property disclosure form, and it is required by the state of Ohio that be signed on all transactions, regardless of whether there's a realtor involved or not. And the fallacy of not getting that signed, for instance, if you were to market your property on your own and weren't aware of that, the buyer actually has an opportunity to walk from that transaction at any point up to the day of closing and actually receive their full earnest money back. They can't be held to the transaction.
Okay. Now, you've both talked about forms, and of course I brought up the for sale by owner. It's probably a little easier now with the internet than it used to be when you'd have to go to the library and see if they had up-to-date books about it. Is the internet helpful to a for sale by owner type of person, or in other words, is it comprehensive enough to assist them to bypass realtors, or are they still possibly going to have some pitfalls?
Mike, my experience with forms being downloaded from the internet has brought a lot of business to the trial portion of the legal bar. It's somewhat that you can perform your own medical diagnosis if you look on the internet.
Take out your kidney stones.
But would it be wise or prudent to do that? And certainly when we talk about kidney stones or a medical situation, I think people recognize the complexity of it, where I think that for sale by owners or buying from a for sale by owner create problems for themselves. They don't understand all the different complexities of things that could go wrong. They have to, for example, comply with the fair housing laws. And when somebody approaches them that might be protected by the fair housing law, a seller who's not trained or experienced might unintentionally violate one of those laws, whereas a real estate agent, well, if someone, for example, wants to rent an apartment, and they call up and they say, I have a pet but their pet is really a service animal. Denying somebody the sale to be able to buy a home or to rent a home because they have a disability or a handicap that requires a service animal is a violation of the Ohio law. Generally, people don't understand that
They
unless
just
they've
say
had
no
some
pets
training.
and that's it. Okay.
You can have no pets, but you can't have no service animals,
Okay.
and a service animal is not considered in the same category as a pet.
Okay.
And purchase agreements are local also. I mean, there are a lot of things that change from locale to locale when it comes to purchasing of real estate. We talked before we entered into here, for instance, regarding tax prorations, long versus short tax prorations.
Tell us to our not necessarily uneducated viewers, but people that would get into this, and it's the last thing they're thinking about is tax proration. They know they're going to be paying the taxes once they buy it, but explain a little bit what that is, how it works, and what time of year maybe that's goes into
Taxes
it.
are typically billed in January and July. Is when you would pay your tax bills. Now, the tax bill that you're paying is actually for a tax bill prior to that period. Most taxes, I think everywhere in the state of Ohio, and everywhere, is billed 6 months in the arrears as far as property taxes.
They're paying it backward
They're
rather
paying
than
it
paying
backwards.
it forward.
That's
Okay.
exactly right. I haven't had a good explanation as to why that happens, but
It's
that
just
is the way
it
they're
is.
billed.
Okay.
Now, the difference between a long and tax short proration, a short tax proration means you're buying the property with the taxes still in the arrears. The only thing the seller is prorating with you is if you're buying the property in April, they're giving you 4 months of taxes, which would be the January to April, which would be 4 months. A long tax proration, if a buyer requested, would bring the arrearage current with the buyer, not the county, but they would be receiving 10 months worth of taxes versus 6 months.
Okay, so that's a negotiation?
It's a negotiating item.
Okay.
And different counties have different customs. It has nothing to do with the county auditor. In Montgomery County, most properties are sold on a short tax proration. You get into Greene, Warren, and Cincinnati, and a lot of those are sold on a long tax proration.
Okay, well, suppose you, and I hate to keep bringing up the for sale by owner type of thing, but let's say there's a for sale by owner and a buyer who is buying it by themselves, and nobody says anything about this
They would have no knowledge.
proration thing, and then they take their deed down to the first, I guess, the auditor, and then the recorder. What's going to happen with this tax stuff?
Well, if you get your bill in July, which would cover, because the cutoffs are twice a year, at the end of December and at the end of June. You look at that bill, it will say this doesn't cover the last half of 2014. It says it would cover the second half of 2013. So the buyer would say, well, the seller owned the property, then why am I paying the seller's taxes? And where that happens, Mike, as Mark points out, we're unique in Montgomery County from most of the rest of the state of Ohio in that we use the short proration. And when somebody comes in to buy the property from outside of Montgomery County and they aren't familiar with this, they feel that they weren't being treated fairly.
Okay, so something that could be negotiated or something that you might have knowledge with assistance becomes a surprise, possibly to your detriment.
At closing, correct.
Okay. All right. We're going to take a very short break. We're about 20 minutes into the program. You are watching You and the Law. We're talking about real estate tonight with two fine experts, Mr. Gary Froelich, real estate attorney in the Dayton, Montgomery County area, and also president of the Real Estate Commission of Ohio, the whole state, and Mr. Mark Kottman, who is president of the Dayton Area Board of Realtors, founding partner of the HER Realty company with several branches here in the area.
We've got probably about 10 to 12.
Okay. And we're going to talk just for a second here about our sponsor, the Dayton Bar Association, which has been serving Our community and legal profession for more than, it's 131 years now, since 1883. We weren't around then, and probably not many of you viewers were either. But the Bar Association provides a variety of community services for the benefit of Miami Valley citizens, including a lawyer referral service. For instance, if you didn't know a real estate attorney, they could assist you in finding one. 222-6102 is the number for the lawyer referral service, and they can find you a person, or you could call Gary Froelich, and because you now know him from the show here. There's a notary public service for applications and testing if you want to be a notary in your neighborhood or whatever, or your job requires you to be a notary. Call them. They can help you out with that. We have a program called Wills for Heroes, wherein volunteer members of our Bar Association will create wills for emergency first responders, firefighters, police, EMTs, and there's one coming up here, and I think I have a somewhere here in, yes, here it is. There's one coming up on June the 7th, and call the Bar Association. For any of you that fit into that category, a member of the bar will help you do a will free of charge. So, not complex ones, but enough to cover you. So, Bill Wheeler's the executive director, and I hope Bill is tuned in. He's doing a fine job and has been for a number of years. So, we'll get back to our program. We understand we have a call coming in, so if the caller will let us know what your question is. Good evening and welcome to You and the Law.
Hi, I have a question about the duty to disclose at the shelter. My question is, say I have a house and I want to sell it, but something terrible happened in it maybe a long time ago that doesn't affect the safety or anything in the house, but it's, something that's maybe unsettling, a crime or something. Am I obligated to tell the buyers, prospective buyers, about this event, or is it the type of thing that they can just find out down the line?
Okay, that's a wonderful and unique question, which I'm going to turn that over to our experts, because I find that interesting myself.
It is interesting, and it is a question which can't be answered as clearly as people would like. What she's referring to is a situation which is categorized as stigmatized property.
Okay, so, and to sort of paraphrase what the caller is talking about, and if I've got it wrong, somebody tell me, but something like a crime's been committed, a murder, mayhem, something like that, and it's buried in the memories of somebody, but it, as you say, stigmatizing the house.
Probably all the neighbors know.
And the neighbors know about it too, yeah.
The neighbors know, and if a buyer found out about that after the fact and they were living in the house, they might feel uncomfortable knowing that something unpleasant happened in the house. And I shouldn't use a word like unpleasant because that's perhaps too mild. But the problem, Mike, is that when we talk about disclosure, the issue is, what do you disclose? If something happened 100 years ago, or if something happened 60 years ago, or if the death was the result of a disease, or was it the result of self-inflicted situation, if it was the result of, what if somebody had a disease that is considered contagious by some people? We don't have in Ohio established rules as to what must be disclosed. The Ohio Association of Realtors recommends that their members disclose matters which they believe would materially affect a buyer of the house. If they were representing a buyer, would they want to know about it? And the emphasis is on full disclosure. But as you know, Mike, our states decide these types of local real estate questions differently, and this is a topic where there's not unanimity of opinion.
And the other problem comes in is that the seller of the property probably isn't going to have that discussion with me, which means that I'm not going to be knowledgeable.
Yeah, as a realtor?
Uh-huh.
Okay. What would be a remedy? I mean, could they set the sale aside? Would it depend on how long the person's owned the house before they find out this event took place, or?
Well, it depends. The cases depend upon when it comes up. Sometimes it has come up before the closing.
Okay.
And in a real estate transaction, we have the time of contract, and then a closing may take place 2 or maybe even 3 months later on. If something comes up before the closing, then one of the remedies might be that the buyer does not have to proceed with the contract. What happens if something comes up after the buyer has purchased the house and they learn about it? Basically, the laws is limited, but the courts have held that the law is limited to measure economic loss. And the economic loss, the cases have said, is what would be the market value difference if that property, if the information about that property was disclosed versus not disclosed. So in terms of remedies, it depends upon did it happen before, did it happen after, and economics is the limitation that the courts have in determining how people are damaged.
Seems like that'd be hard to determine.
Well, the market value is a matter of potentially expert opinion with appraisals, and appraisers can provide their opinion, and it's ultimately up to the courts or even perhaps a jury to decide, even though, as you know, juries have to decide some very difficult questions.
Yes, exactly. Mark, any thoughts on this?
And the problem runs in if the seller's not obligated to disclose it. There's probably some damage that's been done, but if they're not obligated to disclose it, then they don't have to do that. It's their decision.
Well, let me pose a hypothetical, and of course one is a murder or something like in Cleveland where the ladies were kept hostage for a number of years. Or maybe somebody dies of tuberculosis or something, and they've been there for a long time, and the buyer says, well, I never would have bought that place if I'd have known any of those things. And those are my hypotheticals of sort of catastrophic type of events.
The cases that would be the most popular, I mean, we would have knowledge of. And
Right.
if the seller were not willing to disclose, I would have to determine at that point whether or not it's a listing that I'm even actually willing to work with. I don't want to put somebody in that position on down
Right.
the road if they purchase a property that they don't feel comfortable with.
Do you ask that when people are buying the house? Anything else? I guess that falls into the anything else category that I ought to know before we list this.
You certainly have the right to ask that.
Yeah.
You can, and when you talk about murders, there have even been cases, and there's a very famous case where the house had a reputation for being haunted. Now,
Right.
keep in mind, it doesn't mean was the house haunted or not, but did it have that
The reputation, right.
Because having the reputation might impact the number of buyers who'd be comfortable purchasing that home.
It would be interesting, and I do want to talk a little bit about pricing as we go on here, but a lot of the pricing depends on your house, tell me if I'm wrong, as compared to your neighbors or the neighborhood or something like that, plus or minus the condition of your house. And in this instance, you might be talking about a neighborhood with $100,000 houses, and suddenly somebody says, I wouldn't pay $20,000, but I would pay $20,000. Would that be fair to the seller of that house? Or is that another thing that has to be determined in court type of action, do you think?
Well, if it's not acceptable to the seller, they're simply not going to accept the offer.
Well, which gets to my next point, is if this is going to happen with every seller, why would the buyer tell anybody knowing that they'd never be able to sell their house for what they think is a fair market value? Or is that the horns of the dilemma?
That's the horns of the dilemma.
It's the horns of the dilemma, and I think that people should, when they're thinking about buying a home, and this is especially today with the internet and the ability of search mechanisms, much easier to do, but they should investigate. They shouldn't buy a home just on an impulse. They should think about it, they should investigate it, and then some of these things can appear. Sometimes they can't, but at least you reduce the odds of them showing up. And when you deal with a professional like a realtor, those realtors are familiar with properties. They may have sold that particular property themselves in the past, or they may have sold other properties in the neighborhood. They have a collective knowledge in larger offices. So that's an advantage to the consumer when dealing with a licensed real estate broker and salesperson.
So what you're saying basically is don't turn your dream house into a nightmare through impulse.
Use the resources that are available to you.
Yeah.
I mean, if schools are important, then check with the local school systems. If crime is important, then check with the local police stations and get that information. If sexual predators are of concern, I mean, they're in most neighborhoods. So you might want to check and see if there are any in the neighborhood you're interested in buying in.
Which you can do, Mike, by going in Montgomery County to the sheriff's
Online.
office
All that
site
information's
and
available.
putting the address, and you should do that before you buy a home if that's a concern. And another topic that we should mention for a consumer to buy a home is they should consider having a very qualified, thorough inspection of that home before they buy it, because there may be things that are defects that even the seller wasn't aware of. And if they have a qualified inspector, not just a shade tree mechanic type person who says they took a plumbing course many years ago.
Is there a way to find that type of person?
You could do an interviewing process. I typically will provide 3 or 4 different companies and suggest that perhaps they give them a call and they'll talk with them over the phone. And the first thing I tell them, I said, don't necessarily look at the pricing. Sometimes the pricing is indicative of the quality of inspection that you're going to receive. So look beyond the pricing, ask the questions, the pointed questions you need to be asking, and make a determination as to who you're going to use.
Okay. Let's take a very short break. We have a little less than 24 minutes left. And you were watching You and the Law. Our number is 223-5311, and maybe we could put that on the screen in case, no, not yet. Okay, let's put it on the screen, and then our viewers who don't have as good of memories as some of us are fading, I guess, and call in. It's an audience participation show, and you can see that I'm talking right now. But our expert guests are Mr. Mark Kottman, who is the president of the Dayton Area Board of Realtors and founding partner of the Her Realty company here in Dayton, Montgomery County, and of course Gary Froelich, who many of you may know, but is an attorney and the president of the Ohio Real Estate Commission. That sounds kind of important.
It does sound
Tell us a little bit about
important, actually.
Yeah. Whoa. How did you get on that? Is it all attorneys or realtors, or what is that?
The state of Ohio has a structure where different professions are overseen by other professionals, whether they be doctors or dentists or therapists or cosmetologists. They have boards that are familiar with that particular profession. The real estate profession has a licensing procedure where in order to sell property for compensation for others, you must be licensed. And being licensed requires that you abide by the laws of Ohio regarding the treatment of the people that you're dealing with. And if someone doesn't abide by the laws, then they can have their license either suspended or revoked, or they can have other disciplinary action. The system is that there are boards appointed by the governor with the advice of and consent of the Ohio Senate. The Ohio Real Estate Commission is made up of 4 brokers with a minimum of 10 years experience and 1 member of the public at large. and I was appointed to be the member of the public at large. And we hear complaints against real estate licensees as to whether they should be allowed to continue with their license. And we also, Mike, hear complaints against people who practice real estate sales who are not licensed. And I would urge people to be very cautious about working for others in connection with leasing or renting or selling property if they're being paid for it, unless they're licensed, because we've had a number of cases where they haven't been appropriately licensed and there are severe penalties.
Sounds like the thing to do. Well, let me ask Mark, what do you, obviously you can't just go out and say, I'm going to start selling real estate. Will you hire me? I'll take less than all the realtors in town by half, which probably you'd have a lot of people selling real estate then. What do you have to do? What are the qualifications to get licensed to sell real estate?
There are 4 courses that are required to be taken. They have to take those courses. They have to pass a state exam. Used to have to go to Columbus to take it. It's held at a lot of the local areas now. I mean, they set up computers and you take it online. Notified within a couple of days whether you pass. If you pass the exam, you've got 1 year to complete 2 post-licensing courses. And then beyond that, you have to take 30 hours of continuing education every 3 years. There are 3 subjects, core law, ethics, and fair housing, which have to fall within those 30 hours.
Let's say that I'm inspired by this program and decide to stop practicing law and start practicing selling real estate. What things would I need to study about? I'm not going to do that, but, well, maybe I will. Who knows? What would I have to study and what would I have to know to be competent enough to pass this test?
Gary, you teach your classes. Go ahead.
Yeah.
Well, I could go through the index of the textbook.
No, you don't have to do that.
But
generality will be fine.
Purchasing real estate, for example, involves how should you take title? How should you own the property? Should you own it individually? Should you own it with others? Should you own it under a type of arrangement where if one person dies, the other person inherits it? If you are going to buy property, should you be aware of the government regulations? We teach things like zoning, building codes, environmental codes, the Americans with Disabilities Act. We even go into wetlands to talk about it that licensees should be aware of. If statistics show that everybody who has purchased real estate has died, not as a result of purchasing the real estate,
at some point,
but when they buy real estate, they should plan ahead what is going to happen to their interest in their property in the event that they die. And one of the topics that's talked about when we teach the pre-licensing courses is estates and what happens in the event of death. We talk about the contract, a very important document. A contract can be the contract for sale, or it can be a contract that you sign with your real estate professional. If you sign a listing contract with either as a seller or as a buyer, you can sign a contract. You should understand what the obligations of that contract are.
Okay. You're watching You and the Law here at DATV Channel 5. We're streaming live, datv.org. Our telephone number to call in, you still got time. Anything you want to know about real estate, you don't have to pay anybody to find out an answer to the most complex question you can think of out there in TV land. 223-5311. There it is. It's not taking much space up there. Write it down. And we have 17 minutes left where you could call in and get the answer to that question that's been nagging you for I don't know how long. Cocktail parties, whatever. Nobody seems to know. But Mark Kottman, Realtor, or Gary Froelich would know the answer to that.
One of the questions that I want to mention also that's important for potential buyers to be aware of is when they acquire property, should they consider something called title insurance? and whose responsibility is it to pay for that title
And what does it do?
insurance? And exactly, Mike, and what does it do? Why is it important to think about it or even to investigate title? Title insurance is different than what we think of when we think of our fire policy on our home. Title insurance is purchased one time at the time you acquire the property, and it's purchased up to the market value of the property. You can't buy a $1 million title insurance policy on a house that you paid $150,000 for. It has to be the market value. But what it does is it protects you against the multitude of things that can go wrong with acquiring an ownership interest. Somebody might have not been competent at the time that a deed was signed, or somebody might have forged a mortgage release. And Mike, as both of us as lawyers, when we say those possibilities, I can see the faces of real people who had that experience happen, where they might have bought a property, found out afterwards that the
They don't have clear title somehow.
They don't have clear title, and that costs them a substantial amount of money. And one of the things that title insurance does for you is it defends your title.
Mm-hmm. How?
By paying the lawyer and your litigation expenses as part of it, but it also would compensate you and indemnify you to the extent of the loss up to the amount of the title insurance policy.
And in theory, clarifies the title. I mean, that's the whole idea, right? Makes it whole that you get what you have paid for originally.
Right.
In Montgomery County, different than is in other places in the state of Ohio, we place the obligation of investigating title by custom, not by law, but by custom upon the buyer. Other places in Ohio require that the seller bring in title evidence.
Right. And the difference being is who's actually paying for it.
Yes.
If in many cases, for instance, in Columbus, I believe that the seller pays 100% of an owner's title policy. That's incorporated within their purchase agreements. In the Dayton area, and I've chaired the forms committee, other than this year, so I couldn't chair it because I'm president, but I probably chaired it for the last 15 years. We put in our purchase agreement about 4 years ago that we felt strong enough that for the need for buyers to have an owner's title policy, and actually to protect our own agents also from making comments at closing that they didn't need to be making regarding title insurance, that the seller would pay up to $300 of that cost. Now, we came up to the figure of $300 based on an average price range. $300 will take you up to about $120,000 purchase price. Beyond that, the buyer would have to make a decision whether they want to pay the difference in order to get that policy. But with it actually being in the contract, we're probably seeing, I would say we're probably seeing 80% of our purchasers right now in the last 4 years that are actually getting the owner's title policy.
Okay.
Either at the full seller's cost or paying the difference.
A related subject, of course, would be a title search.
Sure.
And probably people buying without attorneys or realtors or selling same probably aren't going to do that, are they?
Well, the lender's going to require it. So they'd have to be a cash purchaser not to have a title search completed.
So what happens there? Who's going to do it? And how far back are they going to go?
Title search usually goes back 32 years. It's done by a title agency, typically in this area chosen by the purchaser. It has to be on the lender's approved list, but most title companies are. So they usually have their choice of going with whomever they wish to go with. They will run the title. As Gary indicated, there are a lot of things that could happen after the fact, though. I mean, you run a title, you get a clear title. However, you find out 6 months later that the city of Kettering or Centerville came in and cut the grass because the owner wasn't cutting it. That becomes an issue that becomes a cloud on the title that at the time of search can't be found.
Right.
So, I had an investor that bought a property, got stuck with a $3,000 grass cutting bill. I mean, it was a bank-owned property.
Couldn't get title because of it.
No, he got title. He had to pay it.
But I mean, wouldn't have been able to get it without paying.
Well, he actually closed on the property, would have been able to get owner's title. Unfortunately, owner's title doesn't cover that particular instance.
Yeah.
So that's an expense he had to pay. We have people that buy properties that are single, for instance, get married during the process, and at closing, they're the only name on the deed. Now, if the question isn't asked or the information isn't provided, they may be the only one signing the deed to the new purchaser, which means you've got a spouse out there that still has an interest in that property,
Right.
as long as she lives or he lives.
And for example, Mike, if a person thought they were divorced and felt that it was legal that they were divorced in some other state, and they said they were unmarried when they sold the property here, their spouse still has a dower right to interfere with the purchaser.
Yeah.
Or if a person didn't know they were married, or what if, and this has happened, forgot about a couple marriages that they had.
Of course, yes.
Because it was more convenient not to mention that to the current person that they married. Well, those are the types of things that can come up with real estate, because the spouses have various interests that can complicate the matter for the buyer if they didn't get insurance.
And one of the biggest issues we come up with, and we see it on quite a few closings anymore, are unrecorded releases of mortgages. That's not going to happen until after the closing. I mean, a lot of the lenders are very quick in accepting the funds to pay the mortgage off and very slow in releasing it. We've seen so many mortgage companies that have sold and transferred mortgages over the years, and they're not selling and transferring the mortgages properly. They're not being recorded. Every time they transfer that mortgage to another company, it has to be recorded so that you can follow who actually owns the mortgage. So if somebody goes out of business and they transferred that mortgage 2 or 3 times, but it wasn't done properly, and they're no longer in business, now all of a sudden you got to do a quiet title just to clear the title on the property.
I hope we're conveying that there are a number of things that can go wrong.
Some little nagging problems. And there was one thing I wanted to ask you about as far as that title search. If you did just a cash sale, maybe you wouldn't have a title search, right?
Well, the realtor is going to suggest one.
I mean, if there wasn't a realtor.
Yeah. If there wasn't a realtor, no.
Okay.
And if I suggest a title search and they elect not to get one, they're going to sign a waiver.
Yeah, right. Okay. Okay, we have about 8 or 9 minutes. I do want to talk about a couple of things. When somebody approaches a realtor and says, you know, I want to buy a house over in Bellbrook or something like that, or whatever, pick your place. Pricing, they say what they're in the market for, maybe the price. How are the prices determined, and how are the costs determined as to what's going to be paid and who gets what type of thing?
Yeah, a lot of the costs are predetermined. I mean,
Okay.
The seller's typically going to pay the commission. The seller pays the deed. The county always charges a conveyance fee. They vary from county to county. It's a transfer tax. It's how the county makes their money off the sale. Seller's going to be responsible for property taxes, either via a long or short tax proration. The subjects that we're not aware of, because we don't have a contract in hand, is whether or not there's going to be asked to be a participation in closing cost, which in many cases, under, let's say, $175,000, most buyers are coming in, putting the least they can put down, taking advantage of the low interest rates, keeping the money in the bank if they can, and asking the seller to participate in closing cost. As far as determining values, we don't do a whole lot different than what appraisers would do. We go out and we search an area. We find 3 to 4 properties that are very similar in nature to the property that we're selling. We're concentrating primarily on sold properties, because you can list a property for anything you want to list it for. That has nothing to do with value. What has to do with value is what they actually physically sold for, because we know at that point that there had to be an appraisal done. We had a ready, willing, and able buyer that was willing to pay a specific price, and we got an appraisal to back it up.
And that probably leaves a little wiggle room for negotiation.
You want to leave some wiggle room. Some sellers think that they need to leave more than they have to. My opinion is that if you price the property fairly up front and the buyer has looked at enough properties to determine that, yes, this is a good value, in today's market it's going to sell very quickly. And chances are they're going to make an offer very similar to what you're asking.
Okay, the $1 million question, what would a typical, and I know it's varies, but what would a typical realtor's commission be, buying and selling?
Well, okay, they vary from company to company.
Right.
They vary from individual to individual. I would say typically you're going to be looking somewhere between a 6 and 7% range.
Okay. And who's paying that? The buyer, the seller? Or should people get their own realtors so they aren't, as they think, taken advantage of by the other guys?
The listing commission is paid. The commission is paid to the listing firm, who in turn offers a cooperation agreement through our MLS. So the agent procuring the buyer would know upfront by looking at the MLS what percentage they're going to be receiving at closing. And that may differ from what the listing agent's getting.
Right.
And Mike, if we think about the transaction, all the money really comes from the buyer or the buyer's
It's built into
lender.
the price.
Yeah, it's built
So
into the
it's
price.
built into the price, so there isn't really a way to say only the seller pays it or only the buyer pays it.
Right.
It's
That's true.
factored in.
Right. Well, I think that's important because I think that is a point of negotiation in just about every sale is, well, I don't have to pay it, or his side has to pay it or something like that. But if you don't have a realtor, you're paying it in a different way, is what
Correct.
you're saying. Okay.
Yeah.
We have a little less than 5 minutes. Tell us the importance of the contract for real estate. What should be in it? Why you need it? What it does in rights and remedies. And I know 4 or 5 minutes isn't enough, but
Go ahead, Gary.
If we look at the contract, first we want to know who the parties are. Do we have all the sellers listed? Do we have them listed correctly? What does the property consist of? Is it properly described? Is it acreage? Is it additional lots? Are there rights associated with that? What else is included with the transaction that we call fixtures? Does the refrigerator go? Does the antennas go? Things, do the draperies? Does that type of issue? There's contingencies in a contract. If a buyer is going to sign a contract, they are planning on being able to qualify for a loan. They want to provide in the contractual arrangement what happens if they can't get a loan according to the terms, or they want to have an inspection. What happens if the inspection discloses a defect? That's something else that the contract should deal with. Sign a contract, Mike, there's a period of time between the contract and the actual closing when the parties meet to transfer the deed and exchange the money. What happens if something happens to the property during the pendency of the contract? Who's responsible? Those are the types of things that should be in a contract. And one of the very important things is to whom the deed should be made payable. People should think that through very seriously, because that has, every buyer has a different arrangement. Their arrangement with their spouses or their partners, or how they want to buy it, and what would happen in the event of a death, or what happens if they have a situation where they don't stay together. Those types of things are factored by how the deed
people
should
don't
be
always
made.
ask that, do they?
They don't ask that. They don't always ask that. And unfortunately, many buyers are not familiar with deeds. I'll put them in touch with the attorney. I'll put them in touch with the title agency to ask whatever questions they need to ask along those lines.
So it's probably a good idea to have an attorney at least look at some things, if not do the whole transaction.
You know, the other important thing with a contract, real quickly, is to make sure that just because something is listed on the MLS as being an item that stays with the property, if you don't write it on the purchase agreement, it doesn't necessarily mean it's going to be there when you go to move in. I mean, you need to write everything down. You need to write everything down to the 10th degree. Everything you want to stay with that property needs to be written out.
So just walking through the house and saying, looks fine to me,
Right.
won't cover it then?
No.
I've been practicing for 45 years. I've never seen a lawsuit where somebody said you wrote too much in a contract.
No. Usually they accuse us of being attorneys.
Well, and we have about a minute and a half left here. We're running out of show. But one of the things that we talked about prior to being on the show is the meticulousness of this very, very important purchase, whether it's a home or, like I said, the store or something like that. Can that be overemphasized? Should you be asking more questions than less? Some people are kind of a pain in the neck and persnickety, I guess is the old term. But
the more questions you can ask, the better off you are. And a lot of those questions can be asked before you even get into the buying process. With buyers, I typically will sit down and go over every contract they're going to get involved with before we even go out and look at homes.
Okay. Okay. I think we have run out of show. I'm seeing 40-some seconds here. Been a very interesting show. We've been talking about real estate. First time we've done this in 20 years. And we're very happy to have had Gary Froelich and Mark Kottman, two experts in this area. And hope maybe to have them back again sometime. The program you've been watching is You and the Law, a monthly program designed to bring Montgomery County citizens, which is you, news of the legal world around them. I want to thank all the volunteers behind the scenes who have helped make this program possible. I've been your producer and host. I'm Mike Monta. Thank you for joining us. We'll see you next time. Good night. I think we're off. Very good. Thank you.
Thank you.
So do we get the royalties?